This is where you've had your tax preparer there, and now you're at an impasse and can't go beyond that. Well, that's when people such as myself get involved to see if it can be resolved still at the audit level by communications or providing information that might be helpful that hasn't been presented yet, just because it would be corroborating information, but nobody's given a thought that that might have an effect on the outcome. And so again, that's generally where I get involved. But at that point, if there can't be a resolve with the revenue agent, then the next thing is to take advantage of the next level that the IRS offers, and that's the appellate level, where you write a formal protest to the agent's report, and then that is sent forward to the appeals section of the IRS, which in this area now necessitates traveling to San Francisco to see and meet with an appeals officer. And it's still not that formal a setting, because you're still sitting in an office room across the desk from an appellate officer. But the difference being at that level is that the appellate officer can consider what is known as the hazards of litigation, as opposed to the auditors at the agent level, the field agent level, or the office audit level that cannot consider the hazards of litigation, meaning that if this case were to continue on even beyond the appeals level, what's the probability that the IRS or the taxpayer, what are the percentages that will be successful for them if this thing were tried in tax court? So, and that can be an iffy proposition as well. So.
Anytime you go to court, it's a gamble, in particular if you had a jury involved in it.
Well, there's no jury in tax court.
Yeah, not in tax court,
no,
but
it's strictly a jump ball, because you can have the strongest case in the world in your own belief, and that's what you have to have if you're going to proceed, obviously. But it doesn't necessarily mean that that's going to be the outcome. The best you can do as a representative is present the facts of the case and the arguments that support what the facts are for the result that your client is seeking. But for example, when you go into tax court and you present all these things, and hopefully they all get into the record, in making the decision, the court can pick and choose what are the most important features to come to the result that the court is going to make their decision on. And that's that's always a little bit of a worry, because you hope that everything that you have put in is very important to the issue.
Right. So we sort of talked around this a little bit, but we're talking a little bit about going to appeals now within the IRS. So first of all, the level of the person that you're dealing with as far as qualification usually is pretty high when you're talking about appeals. You're talking about basically a pretty experienced lawyer that you're dealing with usually, isn't that correct?
Well, a lawyer or CPA, generally you're talking to somebody that's had long experience with the service. One of the cases I have at appeals right now, the appellate officer has a history of having been a revenue agent for 20 years. So you know that you're talking to someone that's got a seasoned background, and over that time you develop wisdom and judgment that's helpful to the resolution of a case.
Right. Now the other thing though is, I guess I'll put it this way, I wouldn't go to appeals. First of all, in most cases I don't think that the taxpayer should probably go and meet with the appeals officer at all. And secondly, certainly I wouldn't just try to go by myself without a representative. Maybe you have a comment related to that.
Well, I've kind of taken the position over the years that it's all right to take your client to appeals. Now, I'm in the minority in that. There's many professionals who say, don't do that.
I wouldn't.
But, and that's all right, because the reason why I do that is sometimes there'll be questions asked that the appeals officer has that haven't been developed at the audit level. And rather than writing down notes on, this is a question, I don't know the answer, I'll get back to you, that type of thing, you have the client sitting there and he can fill in those factual matters. And I've had clients that have gone with me, and they're petrified to some extent. And their first question is, what should I say, or should I say anything? And my answer to that is, your strongest defense is the absolute truth. So if there's something that they're asking a question, and it's something that maybe the client may want to blurt out something that ought not to be blurted out, I'll try and put my hand out just as a sign I'll answer that question. And a good example of that, just so that there's no misunderstanding, is you'll have some clients that have a business, and maybe it might be raising puppies or something like that, and so it's a legitimate business and they're making money at it, but it's also their hobby. And so if they have a loss on it on their tax returns, and you go up to the IRS and appeals and they ask you a question, they say, oh yeah, that's my hobby. Well, that's not a word you want blurted out at that level, even
you want
though
them to even say it.
it's got one connotation for tax purposes and another connotation in their mind, so that you try and, that's the type of thing that you try and separate out. But I would say that your position on it, that should the client accompany you to the appellate, in most instances, probably most professionals would say no. And I just happen to be the exception of the rule on that. But there's a reason for it. It's a matter of efficiency, because I've noticed that when I've gone and clients are not there, and the appellate officer starts asking questions, you go, I don't know, I'll get back to you. I don't know, I'll get back to you. And it just prolongs matters, where if you can get things resolved efficiently, I think that's what the whole purpose in dealing with any of these audit situations, whether it's at the letter audit, the field audit, the office audit, appeals, is try to get through them the most efficient manner possible, because the longer it lingers, it seems like it just gets worse from the standpoint of more issues start cropping up, and if there is going to be a tax to be paid, the interest is running.
Yeah. There's pressure, I think, on both sides to get things done, and so it is something to think about. But the other thing, well, I think that we didn't really answer, and maybe I'll just say it again. I don't think that I don't think a taxpayer should go and just meet with an appeals officer themselves.
No, that's for sure.
Yeah, there's an old saying, that everybody knows, and that is anybody who is his own attorney has a fool for a client.
Correct.
And that's particularly true in this. It's a very sensitive area that you're dealing with. The people that you're dealing with at the IRS, although you and I try our best not to be intimidated with them, they have really an awesome amount of power.
Right.
And so we want to handle that very carefully. Okay, we've got about 5 minutes left and just a few more questions. Are there items requested by the IRS that the taxpayer is not required to provide?
Well, I've never run across that, but I know there's a school of thought. Sometimes what the agents will request in an audit is the prior tax return to the year that's being audited and the succeeding return to the year that's being audited. Some practitioners take the position that you don't have to provide that. And the reason why the agent's asking for that, or the auditor's asking for that, is they use a comparison. Maybe something that appeared to be out of line in the year that's under exam is also a same number on both the prior and succeeding returns, which may be a double-edged sword. It could mean that, hey, you've got a horrible result going out for 3 years, or that this thing is consistent and that there's just a typical normal business reason for that type of expenditure. But that's the only thing I can think of, because most of the time the agents are going to ask for things to which they're entitled. I've not experienced anything where they've asked for documents that don't pertain to what's being looked at on the tax return.
Okay. I provided the stuff that the agent requested, and now I've got another document request. Why is that?
Well, once they have a return assigned for examination, the agent may have, or the auditor may have, an item specifically that they're supposed to look at and resolve. But agents, particularly in field audits, are responsible for the entire return. So that once you get into an audit, maybe there's something else that crops up, and so then you get another document request with respect to that item. But it can start out with having one item being looked at, and then it can be expanded to other items on the return, and that's very normal, and it's within the purview of the service to do that.
Okay. So when you get a notice for an office audit or a field audit, well, typically it's actually an office audit, I would think, that they specify a time and a day. So are you stuck with that?
Pretty much. They'll let you rearrange the time if it's inconvenient for you, but an office audit is just what it says. You're going down to the IRS to meet with an auditor, and in most cases in an office audit, they are going to be limiting their examination to the particular items that they're requesting. So it's rare that an office audit will get expanded. It's less rare on a field examination.
Mm-hmm. Now, if they specify a date and a time for a field examination, we have more flexibility related to that?
Oh, for sure. Yeah. You can specify the time, and if you would rather have it, a client would rather have it at the CPA's office, have it at the office or the representative's office. And typically what the agent will ask in those cases is, all right, I would still like to inspect the business premises, and you can arrange a time when that's a workable thing. For example, if there's a business and the owner of the business is being examined, and you have employees out there, sometimes it can raise questions in the employees' minds if you see this revenue agent walking around and they're wondering what's happening to the boss in this situation. Mm-hmm. So in those instances, you can arrange a time where they can see the premises and it won't be a distraction, and go on with their examination so everybody is taken care of.
Okay. Gee, we only have a minute left.
So I've out talked.
You've done just fine.
Okay.
So I think what I'm going to do is, rather than continue on, because we know that we can't cover, necessarily everything in, less than a half an hour. But maybe you have a final word of wisdom that you'd like to throw out for people related to IRS audits.
Oh, sure. And the thing is to be forthcoming. If you've prepared to return honestly, and you shouldn't have any concerns. Whatever it is, if there is a mistake, it's going to be an honest mistake. But the point is to be completely honest, open, and communicate. Those are the biggest things to get the thing resolved.
Okay, that's great. Okay, Bill, well, first of all, I want to thank you very much for coming and being my guest and sharing a little bit in this area with us. Folks, I hope that we've given you something to help you to be more aware, maybe a little less frightened of this process. And the good news, I guess we could say, is very few people seem to get audited when you look at the overall percentage of tax returns. I think it's a good idea to get help, and especially when you're having some difficulty with the agent. So with that, I hope you've enjoyed this program, and we'll see you next time on Financial Insider Weekly.